G'day, Nina. How are you?
Good, thanks, Andrew. How are you?
Love you. Were back last week, were you?
No, I was
No,
sick.
yeah, sick. Well, it is nice to have you back.
I feel like illness is just hitting our team
I
in
know
different
Kim's
parts.
knocked out at the moment.
Yeah, Kim's sick.
I've
I
actually
think
given a
Tom's getting
direction.
sick
I've given
too.
her a direction to stay home and to not work
Good.
today, early today.
Oh,
Anyway,
gosh.
welcome everybody. We've got a pretty full sheet today, and we've got some industrial cases which shine a lot on the confusion that sits in the Fair Work Commission around industrial matters, which is only going to get worse with new legislation that comes through. And we're looking at particular cases around individual conduct and behaviour and how that actually plays out in a number of different areas of law, because we thought that might be an interesting focus for today as well.
Mm.
We'll say it again, but I want to say it now. We have our right of entry breakfast coming up in a few weeks' time. You'll see at the end what time it's on. I've got John Darcy coming along, who I think is without doubt the leading safety person in this space and has been involved in actually writing parts of the provision in the safety legislation. So John and I will be running this so that you can actually not only understand the simple part of who can enter when and how, but how do you actually manage it when it's being used as a deliberate strategic attack on your organisation.
Yeah, like practical tips on how to manage the union.
Thanks.
Yeah, I could summarise that in a sentence.
And she did. Yeah. It's nice to have her back. Okay, why don't we get in the first case though, which is the OSM case. All right. Interesting case here because this is about unions having rolling industrial action, including bans.
Protected one, not unprotected.
And one of the provisions of the legislation allows you to reduce the percentage of payment in a day by the amount of real-time lost work.
Yeah.
Not an easy calculation.
Yeah, because, well, normally I think with protected industrial action, they often do no work. But in this case, because they were all on a ship, there were crucial things that had to be done. Otherwise, basically, the ship wouldn't operate.
And on that basis, what they had to do was determine what was the percentage of time they were working versus not working. So the company obviously took a more stringent view and said 90% of the time they weren't working, and so they deducted 90% of their wage and also
their leave
loading, which under
their leave accruals,
which
is unlawful.
Which is unlawful. And they got through to an appeal process, which reduced it back to about 29%.
That they worked.
They worked.
So it was about 65% they withheld from wages and no allowance to withdraw from leave.
But look, can I say, really simple thing. All you do is you create a table, because I like tables. What is the work someone is supposed to be doing? What is the work they're not doing? And then you look at it as a percentage of the day. That's actually the method of calculation. And then they can always apply to the commission if they're dissatisfied with it. So look, really simple, interesting case, which highlights a big issue when there's industrial strife, particularly as unions are taking less stoppage now and they're doing strategic banning where they deliberately try and work as much as they can, as slowly as they can, but stop doing particular things. So the idea then is to identify the impact of what they're doing upon work. Let's roll on to the next case, which I think is, I think this is a bit of a bizarre case, really. This is one of the most wealthy organisations in the world, Sephora.
Yeah, I like that Tom put in brackets beauty organisation, because you would know that.
That's right, thanks, Tom. Louis Vuitton Bank Group. And what they did is they were rolling out an industrial agreement in Australia. The union had very small amount of involvement or interest. They sent them a
copy of their
notice
to their offices, but apparently got lost.
But there's proof that they received it. Can I just say, one of the things, whenever you're going to send a notice to the union, please get somebody to go and serve and prepare a stat deck afterwards they've done it. That completely stuffs what the union's done here, which is, we lost it, it's not our fault. Sephora didn't let the union know about
any of the meetings because they didn't reach out.
And with an hour to go, they were in an urgent application by the union saying, look, bad bargaining, you didn't invite us to meetings.
Yeah, it's an hour to go before the ballot to vote it up was finalised. That they applied to the Fair Work Commission.
And 80% of people said yes, and so the Fair Work Commission said, bad luck.
Yeah.
And then they said, well, look, it's still it's not bargaining fairly. It's still wrong. And the commissioner said, but the deal's over.
Yeah, they were like, which I don't think it was really bad. But I think in this case, the union had made it clear they wanted to be part of the process. So probably you could argue maybe Sephora had been a bit more sneaky with it. But there's nothing in the act
And
that
the
says you
union
have
brought the wrong
to.
application. They should have brought a stop order.
Yeah.
They should have brought a stop order to stop where it was, to stop counting so it
Yeah.
was live, and then argued it.
Yeah.
But anyway, I'm glad the union weren't that smart. That's where we ended up. But it just
This is
shows the
crazy.
level of confusion that sits around good faith bargaining, because if there was a prima facie case of lack of good faith bargaining, the commissioner should have stopped the vote.
And you could invalidate it even if it's been voted up.
Yeah. So anyway, that just shows you how complex it is. Let's jump on to the next one. All right. I just think this is the best case. This is a union in Western Australia, Ramsay Health, arguing on television, on radio, on social media, that the nursing numbers to patients were lower than public.
So this is the union arguing.
And it was false. And they were told by Ramsay to stop it and to remove it and to apologise, and they refused. So they brought an application saying misleading and deceptive conduct. And the union said, well, under misleading and deceptive conduct, we've got to be involved in trade and commerce. We're a union. We're not.
Yeah, they said that advocacy was not.
And what the court said quite rightly is, no, by doing what you're doing, you are interfering in client selection and client fears in relation to a hospital. So it is trade and commerce. And so they granted the interim order. Can I say this is a really interesting case, because it is the first where competition law has been used against union misrepresentation.
Yeah.
So I think let's park that to where we need it when we're dealing with unions. So we start writing the right letters about campaigns which are dishonest. Yeah. Okay, so a fascinating case.
Yeah, and I will say the union in this case did withdraw the advertising stuff, but what they refused to do was do the retraction and apology. And even though they did the first bit, that wasn't enough for the court to say that's sufficient.
Yeah, no, the damage is bad.
Definitely should pursue it.
Okay, well, now we jump back into the more individual cases, and we're going to deal with a couple of workers' comp cases. VCB and Australian Post is a case of really what is a nasty man complaining of being victimised. The evidence that came out is polarised between his version of events and his manager and everybody else's. Yeah. And what everyone else said is they're a bit threatened, a bit scared. This guy wouldn't talk to them, and he complained about being isolated.
And he was saying they were the bully, and he was bullying everyone.
And this is very rare that workers' comp law get anything close to being right, but this is a good decision, because what it basically said is, look, the guy's got a personality disorder. He creates this type of noise.
He'd done it in previous workplaces.
Yeah, he's hurt by himself and his behaviour, not by the workplace, and therefore it wasn't compensable. So I think really interesting and good decision. And as you're arguing against these difficult people, where you're doing performance management and they're raising these concerns and they're putting in work, this is a good case to remember. Okay, let's go on to the next one, which is
the school cleaner one.
Launders, the school cleaner.
Oh yeah.
Sorry.
Laundess.
And it's a female as well. Laundess, the school cleaner. Anyway, school cleaner saw a car light was on when she was cleaning around the main gate. It was outside of the premises.
Yeah, she went to go turn it off and tripped.
And she tripped over a curb in Chenham and brought a workers' comp claim. In New South Wales, where the claim is brought, the authorisation of absence, that is, when you leave a site, when you're entitled, requires the consent of the employer. And really what the court found here is, well, this was a very autonomous role. She was a cleaner. She'd come and go as she pleased.
And take breaks whenever she
wanted to, and therefore the provision really didn't apply, and therefore it was compensable. So why is this case important? Because in every jurisdiction there are very similar provisions, and when we provide that level of autonomy in the nature of people work, we understand that as they walk outside of the workplace, they are exposed to different risks.
Yeah.
The classic one is hospital workers going home at 11 o'clock on a Saturday night and there's a pub around the corner, as one of our case studies once had, where people are walking down a lane to go to a car park, and the car park is dark and inherently dangerous. So please be aware of this issue, okay? If you have autonomous working in people who can come and go, then you have risk that comes with it. If people are seeking consent to go out, then be clear about what the consent is for and limit it. Because if you don't consent, there can't be a claim. Okay? All right, we're racing through these. We're doing all right, aren't we? Okay.
You're speaking very fast. So this one was an interesting one. It involved a company who was installing controls to prevent a concrete pour from going too
They
far.
were ties. So in other words, they held the wall up where you poured the concrete down.
But the way that they installed the ties was not in line with the engineering designs because they welded them. And with these particular ties, if you welded them, they would crack when any exposed to heat or any kind of heavy load was put on them. And so what happened is one of them broke, and instead of going back to check with the engineers, what should we do? They installed a steel beam as a temporary measure. And then basically an hour later, a whole bunch of them cracked. I think it was 15 cubic meters. Yeah.
Concrete poured out.
And it was extremely dangerous. Luckily, I don't think anyone was actually hurt, luckily. But yeah, they got slapped with
they got slapped with a series of fines, quite 140 for one of the people, 100 for the other. But what was, I guess, one of the reasons we put this on is, one, when you rely upon expertise and then you don't follow it, you're going to be liable.
Yeah, that's like the easiest way to expose yourself.
That is sort of so dumb, it's unbelievable. Yeah. Because when you look at what is reasonably practicable, you identify a hazard, okay, you recognise what the risk is, so you get an expert to institute a control, then you fail to follow the control.
Yeah.
Like it's just bang, liability.
Like it's taking the liability back from the expert.
But the second thing, which is happening now throughout Australia, is safety regulators are no longer just prosecuting the primary breach. Any failure to comply with process, in this case there were 2 fines for $5,000 for failure to provide documentation as required. So what I want you to understand is we need to actually play the whole game with the safety regulator now. It's not enough to actually defend through legal professional privilege and everything else you're doing to actually try and reduce or mitigate the likelihood of prosecution. You've got to make sure that all the procedural paths are actually ticked and right, because each one of them will be prosecuted along the way. Okay, let's move on. I reckon a timely reminder about rolling guarantees. So guaranteed of earnings exists as a mechanism with inside employment contracts where people are award-based employees but would earn over the high income threshold to have them excluded from award entitlements, so long as they contractually do it and there is a set time or term in respect of that part. So there's 2 parts to this. There is the contract and there's contract management that follows it, because you can't have an indefinite term.
Yeah, well, it just has to be in writing. It doesn't have to be, but that's the easiest way. Yeah.
So let's talk about this case. You know more about this case than I do, or have I thrown you in the deep end?
No, it's fine. So I don't think the facts are very unique. Basically, this guy was made redundant and he was trying to claim that he was entitled to entitlements under the real estate award, and they said no, there was a guarantee of earnings. What was really the key point in this case was whether guarantees of earnings can be done on a rolling basis, because the requirement is it has to have a start and end date. And the previous case, I think it was a Peabody case, said that every time you did a guarantee of earnings, it had to be like start from the 1st January, end of the 30th December, you get this, and you'd have to do another one each time.
Yeah.
And in this one, it said it'd start on this date and it would end at the end of his employment, and he would get, I can't remember the amounts, X amount for the duration. And the court found in this case that as long as there was a clear identifiable period, there was no issue with having it on a rolling basis, provided that the amount that was paid to the employee remained above the high income threshold each time.
So really, when you're doing your REM reviews for persons like that, it's in the letter that goes out, you just speak to Nina and we'll put in a clause which actually gives you that level of comfort, because I don't think this case is completely right. Can I just say, I don't think it meets the intention under the explanatory memorandum for what this provision is about. And I think if you vary the amount the person is paid, I think it undermines the efficacy of this decision. So at REM time, that's when you put in another clause, because remuneration review is varying a contract of employment. You vary it and remind them this forms part of this above the high income threshold, and this is part of guaranteed earnings, so that you don't have the complexity. Where are the types of employers are going to see this? We're going to see it in health. Okay, we're going to see it in education. Yeah. We'll see it in some people who are hired in aged care. We'll see it in some engineering and other roles that are related to construction, manufacturing, and finance as well. So I just want you to think about if you've got someone you know is going to be over the high income threshold for an entire year,
And they're covered under the award.
Yeah.
It doesn't apply to EBA covered employees.
Okay.
But you got to be done really carefully, because if it's not, then it'll be invalid and they are entitled to the full gambit of everything.
Okay. So worth doing, isn't it? Well, I think this takes us to the big issue, doesn't it?
Main topic.
Main topic for today. Yeah. Look, I think over the last, well, Nina's been away a lot, so I can't really talk about that. But we have had between us a number of cases of social media behaviour inside organisations, and it falls into two categories. What is social media behaviour that forms part of employment? And what is social media behaviour which is outside of employment but under Telstra? The Telstra case forms part of it for effective discipline and control. Okay. Yeah. The case we're going to deal with is Brianna and what's the name of the case? I always forget the last part of the case. But anyway.
And the Dolphin Hotel.
And the Dolphin Hotel. Yeah, what a great name, Brianna and the Dolphin Hotel. Right? So in this case, it's a really complex case, but effectively she was a person who underperformed as a bar manager. They talked to her about that. She agreed she'd been underperforming. They had a discussion about her behaviour and being a positive influence on staff. She then took to social media, which was a WhatsApp group of people.
Dolphin Fan Bam.
Fan Bam, wasn't it?
Yeah.
Yeah, and then sort of encouraged people to criticise management and acted in a really inappropriate way.
And then removed management from the group too, so they couldn't say it.
Yeah, dumb, really, isn't it? That you should have fired her for just being stupid. But I didn't say that, did I? I did. Sorry, I'm tired. At the end of the day, they had a whole lot of problems with her. This wasn't the only problem. This was one of a whole lot of problems. So she would have been sacked anyway, is the truth of it.
And they did talk to her about it. Like, they didn't just go to sack her.
No, the process they've done is terrific. But what they basically said is this is part of work. Now, it wasn't argued well in the case, okay? Because there could have been some very good arguments about the timing of when things were done, about the nature of the group that was being involved. But the short answer is, even if this was outside of work when they were making this communication.
Yeah, on her private social media.
Yeah, on a private social media. It would go to the heart of the nature of the relationship because it identified the employer. It was critical of the employer, so it goes to reputation. So Regulation 1.7, what's serious misconduct? Something which goes towards the reputational financial viability of the business or safety of it. And it undermined the relationships that existed in there. So it's clearly a breach of a prior lawful and reasonable direction. So whether it's out of work conduct or in work conduct, I think there was an argument that could have been mounted better on the out of work conduct. But the fact it is a WhatsApp group with only employees, whether it's voluntary or not, and they're talking about work and people at work, and they're saying bad things about people at work.
Such a clear connection.
Yeah, I think it's terminable. So I think it's just a great case because people have Slack channels and methods of communicating internally, and I look at them when I'm acting for people, and there's stuff that's on there that should just never be there. There's stuff on phones when we download phones that people should never have said to other people.
Yeah, but I think why this case is important is outside of all those channels which are very clearly linked to work, Slack, Teams channels are things you use for your work. Now what the cases are saying is for social media unconnected to work, there can still be a connection.
And that goes back to Gajedi and the Minister of Transport case here, which basically says, look, privacy only gets in the way of investigation if it would be okay for you to ask Nina first before you went and had a look at a post. But if the likelihood she would delete the post, then you can go to the post even if it has a high privacy setting. So privacy settings alone don't prevent you from looking at it. But that's a more complex issue we can talk about another day. But look, I thought it was a fascinating case. Yeah. And I really do think it reminds people, particularly at the moment when we've got this virtual working environment.
And keyboard warriors.
Yeah, and we do have keyboard warriors. They've really taken off. There's a whole army of them out there where people are starting to say and do things because they don't have to sit next to someone. I think it's probably time to draw a bit of a line in the sand in all business and say, look, good conduct is good. It's not this. And if you do this sort of behaviour, we're going to deal with it.
Yeah, but Andrew, it's clear that it's not just a free-for-all, right? Like, employees still have a right to say their things, but It's just whether it's very clearly identifiable as the employer. So there is that delicate balance.
Yeah, there's that interesting case with his name is escaping me, who was the prison
very complicated
the prison warder case where he was part of the new right and was saying some pretty horrible racist sort of things. But it wasn't about any individuals. It was just his views. And they're pretty bad. Now, in some organisation, that behaviour would be fatal for his employment as well if it was directly connected to the nature of care or advice.
And his role, yeah.
Anyway, good decisions, good discussions.
Case.
All right. Well, look, we've done that. We've done and dusted. Let's go on to the problem.
To the case study.
Here you go.
Naomi was tired. It was the end of the month, and her role in accounts meant she had to help settle the monthly accounts and have reports ready within 3 days of end of month. As the senior accountant beneath the CFO, the crazy task of getting financial information from people throughout the business who habitually failed to hit deadlines and follow policy was a nightmare. She felt it was thankless. Flexible work meant her team were only in the office 2 days a week. She realised their absence prevented some of the simple methods of chasing information by walking to where a person works and asking it. Now it was just endless emails. She told the CFO, Miles, her concerns and asked him what was wrong with coming to work. He explained if we go back to people always coming to work, no one will work for us and our best employees would leave. Naomi considered herself one of the best employees and she came to work every day.
You can see we've got a problem with Naomi there, by the way. I just thought I'd add that in. Just to highlight it.
On the day before the end of the month, she rang Miles. She explained in a somewhat overwhelmed and excited fashion that operations had not forwarded any relevant data and she and her team would be up all night the next few days to meet his arbitrary deadline. Miles had grown accustomed to Naomi's sense of high dudgeon. Dudgeon?
Yeah, that's right. No, I put it in for you.
He explained it was not his deadline. But
high dudgeon is being overly excited, fearful of everything.
I feel like she just smelling where the blood in the water sort of shut. He explained it was not his deadline, but a mandatory reporting deadline for the owners. He said he understood and would chase operations and apologise for the pressure. When he spoke to the head of operations, she explained all information had been provided on time and Naomi was caught up on one of their characterizations of waste and wouldn't accept it. She said it was the method they always use. When Miles rang Naomi back, she flipped out. She said, "How dare you go behind my back?" The way they describe waste is critical as the KPI is no more than 2.5% and they say 2.1%. And on my calculations, it is 3.1%. I can't move forward until it is resolved.
There's some problems with Naomi, isn't there?
Naomi sounds like so much fun. Miles said to use their method and he'll arrange discussion later to settle it. She burst into tears and hung up. She immediately messaged her 2IC Kane, a habitual whiner.
Nothing to do with Kane Corns, by the way.
Sorry?
Nothing to do with Kane Corns in football. It's not why I chose the name.
Okay. Complaining that Miles didn't back them on waste and doesn't care how hard they work. He messaged immediately, calling Miles a number of unsavoury things to which she posted a smiley face. Late at night, Naomi went online to fix the waste issues and connected on Slack with her team, including Kane. He had already let the group know what he thought of Miles. Naomi, lonely, angry, and having consumed 2 glasses of wine, agreed with Kane. She said Miles was a fool, innumerate, and careless with his team. He was lucky to have them. Kane again inserted some very unkind words, and Naomi endorsed them. The team all agreed. The nature of the language brought up a red flag. Your red flag.
Do you want me to get one?
With our team, who captured all the discussions and forwarded them to high HR, who further obtained a download of the phone messages.
All right. So the first question was Naomi and Kane's conduct connected to work under the Rose and Telstra doctrine. So this was out of work. Well, the answer is you don't actually have to go to Rose and Telstra because they were participating in work.
Yeah.
So I just wanted to show you, because of virtual work, the world has changed a bit. For Nina and I, if we communicate with each other at 8 or 9 o'clock at night, it's actually work because we're working. So don't focus on what is actually happening. If people are at work and doing things, it is work, even though it might be outside of hours. Okay?
Yeah.
All right? That one was easy. Was there anything that Kane and Naomi did that would substantiate misconduct? And if so, was any of it serious misconduct?
Substantiate misconduct. Well, yeah, they were saying inappropriate things.
Totally, yeah. It's utterly inappropriate. It's serious misconduct from both of them.
Because they were encouraging other people to say bad things.
That's
too,
right.
Weren't
they? Yeah. If Miles sought to terminate Naomi...
Was it serious misconduct?
Yeah, it was. Yeah, it was serious misconduct. In fact, it's fair to comply with lawful and reasonable directions about values of a business, which you're trained on how to behave. No doubt there's policies and other procedures, but it's clearly just in not acting in the best interest of the business, which is a common law duty.
Yeah, so they probably should have raised it through like a grievance procedure or something like that. Miles thought to terminate Naomi's employment. Would she have a good general protections claim?
Now, she's raised safety issues. she's raised all sorts of issues with Miles. What do you think?
It's not why she's getting terminated.
No,
so
she's being because she's a pain.
No.
She is.
She's getting terminated because she's engaged in misconduct.
And she's a pain. Okay.
That would go to the complaints.
No.
A pain because she raised too many complaints.
No, she's just a pain anyway.
Were there any psychological hazards, and if so, would the regulator prosecute?
Look, there are some psychological hazards in the sense that the organisation of work is inadequate, and you've got a Naomi there who has all these stress-related issues, and you're not managing it.
Yeah, but she also is not really engaging in the consultation.
I've used Naomi, not that anyone called Naomi out there should think it's them, but it's a very common factor in the financial divisions of organisation, which are high-pressured organisations, to have people who are highly detailed orientated, but inflexible and difficult to deal with.
Mm.
So you take your culture as your fund. It's a bit like an eggshell skull as well. So the reason I put this question is I don't think anyone would prosecute.
No.
But if Naomi did something to herself as a result of the types of pressure she was under, given her known vulnerabilities, given the nature of the role, I think the organisation could have some trouble. Okay, so can I just go back to this? When Nina comes to work with whatever's happening in her world. Okay, and that's Nina the moment she walks through the door. She's just not work Nina. So if I've got somebody in my organisation who's fragile, tense, difficult to deal with, I've got to deal with her. I've actually can't just let it happen. And if I let it happen, then the regulator will get involved if something terrible happens. Okay? Because like people, you take your culture as you get it. Okay? 5, if Naomi went to the doctor following the discussion with Miles and put in a work cover certificate, would her claim be accepted if she could prove a genuine psychological health issue? So she's had the conversation with Miles. Okay, this is before
complained about all the work
pressures she's got.
Yeah.
And the answer is I think her claim would probably be accepted in nearly all jurisdictions. Okay, because there's no reasonable management defence here, because it's not about reasonable management. It's not about discipline. It's not about counselling. It is her subjective response to pressure.
I thought in Victoria, though, burnout was not compensable anymore.
Well, no, she's got a psychological illness. So she's got a genuine psychological illness. So it's not a burnout.
She's got a genuine what? Sorry?
She has genuine psychological health issues.
Oh,
so
okay.
She's got to define. So no, you're right. But the issue which people forget is reasonable management action deals with how you administer work and manage a person. Okay? With her, she is having a subjective experience of stress based on the nature of work that she's undertaking. In workers' compensation, it is subjective apprehension of that makes it compensable, so it would be compensable.
So they would still have to look at her work design, even if they think someone else could have.
Which is why the question falls in there, just to remind you, you have two choices with a difficult person. One is get rid of them. Okay, that's a really easy and sensible choice. Or two, if you're going to keep them, then you're going to have to build a set of controls around them so that they're safe and other people are safe from them.
Yeah.
All right, well, let's go to the last slide because it's an important one. This is what we're doing, union rights of entry, what you need to know and how to manage it. I'll be there with John and the team and Nina and everybody else going through what the law is and then actually strategically how you manage unions who seek to use right of entry. We're getting a large amount of right of entries done on psychological hazards where there's no elucidation as to
and they're pushing the boundaries.
Who or what. So we're going to talk about all of that and we really look forward to seeing you. But until then, Nina?
Yeah, but please, if you want to come RSVP to our admin email.
Yeah, RSVP to admin. So do we put that back up again? We put our slide back one more time? We do, look at that.
admin@fcwlawyers.com.au.
Okay, can you see that? Okay, guys, thumbs up.
Thank you.
Thank you very much. See you later. Bye-bye.